This is the Matsen spectrum of fraudulent conveyance applicability. And I want you to know this, and it should be emblazoned across the doorway of your memory. And here's it is. The further on you are down the spectrum, the line, the easier it is to prove a fraudulent conveyance. Okay. If you're on, and a lot of people don't understand this because actually it's not when the claim is, your clients don't understand this especially. It's not when the claim is asserted. It's not when the lawsuit is filed. It's not when there's a judgment that the Fraudulent Conveyance Act kicks in. It kicks in here when the physician leads the sponge in the stomach, when the attorney drafts a faulty document, when a client signs the guarantee, when the environmental laws are broken. So this is where the fraudulent conveyance kicks in. Now, if you're over here, is it a safe haven? Are you okay? If there's no creditors except on the other side of the line, and those creditors are called future subsequent creditors. And the law, I believe, the law is that if, as long as the creditors are here, as long as the facts haven't occurred, and that's when we would try to get the clients in to institute the plan. That's the most favorable time to do it. The cases hold, and it's universally accepted among almost all practitioners in the area. And I'm on the American Bar Association Subcommittee on Asset Protection Planning. There are a couple of lawyers that don't always agree with this, that are well known. One of them has a big website. Well, both of them, they're partners, and one of them has a big website. And is they're both friends of mine, by the way. And I've even made presentations with them on several occasions, and so we disagree in the presentations. But I think future creditors are absolutely barred by an asset protection structure unless, and by future subsequent creditors, I mean people here. They're on this side of the line. I think they're barred unless two factors. Number one, the client is on the eve of undertaking a very risky transaction or incurring a known debt. There are some cases where the courts have said, then from their standpoint, the client is really here instead of on the other side of the line. The other is if there's been an intentional misrepresentation of ownership of assets. So where the client then intentionally misrepresents that they own assets that they have created as part of a structure, an asset protection structure. And that's why I told you that I represent several car dealers, and they come to me in this, there's been a whole new arrangement with the automobile makers and manufacturers. And what I told them to do is to submit their balance sheets without showing the assets that are in their asset protection structure. So that they can't, the car dealers, if they come against them because there's been a default, they can't argue that they were misled and there was misrepresentation, because they've approved the dealers based on the basis of, and the reason there's not, what's the reason that they give why the assets are not included on their balance sheet?